We are in Florida, where defendant Laurie Shaver was back in court for a motions hearing. The Clermont, Florida mom is accused of fatally shooting her husband, Michael, back in 2015, and then burying his body in the backyard underneath a concrete slab. Prosecutors say Shaver then went on to use her husband's phone and social media account to send messages to his friends and family in order to avoid suspicion. Shaver was arrested for the murder 5 years later in 2020 and now claims that her daughter, who was just 7 years old at the time, was the one who actually shot Michael. Before we get you back into court, here's Court TV's Julia Janae with more on the case against Laurie Shaver.
November 7th, 2015, 33-year-old Michael Shaver left work as a Disney World mechanic and was never seen again. 3 years later, local station WFTV was there as Lake County, Florida police dug up his skeletal remains. They were buried under a concrete slab and fire pit in his backyard in Florida. He had been shot once in the back of the head.
Not every day somebody digs a body up out of your backyard.
Michael Shaver was married with 2 young kids when he disappeared. His wife, Laurie, told his friends and his employer that Michael had left her and moved to Georgia so they could work on their marriage.
My name is Laurie Filmer, also known as Laurie Shaver, and I'm a devoted mother. My life is my children.
According to court documents, friends and family received text and Facebook messages from Michael after he disappeared, but they said those messages didn't sound like him. They also began to question Laurie's decision to give away or sell Michael's guns, tools, and car.
The word crazy, I think, sums it all up.
In February of 2018, Michael's best friend asked police to conduct a wellness check. Laurie initially cooperated with police, but later refused to let them bring a cadaver dog to search the property. A month later, Michael's body was found.
She's always been a suspect, yes. We've always considered her a suspect. Detectives are confident that she is the last person to see Mr. Shaver alive.
In 2020, Laurie Shaver was charged with second-degree murder. She pleaded not guilty. In 2023, her defense team filed a notice that they wanted to introduce evidence of prior bad acts and violence inside of the home. The motion further states that she did not shoot and kill Michael Shaver, but that their minor child, who had just turned 8 years old, acted to protect her mother.
I am not guilty, and anybody that knows me knows that my life is my children.
Laurie and her attorney posted a YouTube video to assert her innocence and ask for donations to fund her defense.
I had nothing to do with the murder of Michael Shaver.
Let's get you back into court now for more of that hearing. The attorneys are still arguing over the state's notice of intent to rely on the evidence summary.
Stated that you can't link the IP up with the digital data because it expired. I don't think the state's going to put that in a summary. Okay? Richard Connor said all that data is expired. It can't be linked to a device, a location, or an individual. And that anybody that used a router had access to that same system. But at this stage, none of the data links to an IP address. And so we heard technical testimony on that, of which the state didn't refute at that hearing. I'll point out to the court. I talked to the court, I said, these are the foundations, these are the predicates, of which the state offered no evidence, how they would try to establish a predicate at trial. So the only thing they did is they ushered in a bunch of documents and said, these are a business record. Now they're seeking to develop a predicate through a summary, of which the state just objected to the plausibility of the defense doing the same. So it should be denied.
All right, anything further?
No, sir.
The state's motion is granted. The state may admit evidentiary summaries pending proper foundation. We'll move on to number 4. State's number 4, fourth motion is a motion to prevent exclusion of witness. Please proceed.
That's Doug, yeah. That's Doug. Yes, Your Honor, this is pretty pro forma, pretty standard. The victim's father in this case, Doug Shaver, has requested to be present during the trial. He will be called as a witness, probably towards the beginning of the state's case. The Florida statute that I cited in my motion indicates specifically that the next of kin may not be excluded from the courtroom during this type of a trial. So we're just asking that Mr. Shaver, being the next of kin of Michael Shaver, be permitted to watch the trial.
We don't have, I know that there's a discretionary concept with that same rule that allows the court discretion in whether to grant it or to deny it. We don't have any problem with Mr. Shaver sitting in during the trial. We would ask the court to instruct Mr. Shaver that he's not at liberty to speak to anybody during the trial about anything that he heard within the courtroom. And that the rule of sequestration would still be applicable to him even at the conclusion of his testimony, because we're not going to release him.
All right, as a stated agreement?
Yes.
All right, then, without objection, a motion is granted.
Thank you.
The state's fifth motion, the state's response to defendant's motion for presence of prospective jurors during the entire voir dire process. So this goes to Mr. Woods' motion to permit the diary to be present when we are at the bench selecting the jury members.
What I've asked judges that they remain in the courtroom during the entire voir dire. And I've expressed in the motion the basis for this. I know the state didn't voice any objections, saying they'd leave it to the discretion of the court, but the concepts were to allow the witness or the defendant not to be confused, to be able to look at the prospective juror to the conclusion, know if they want that witness, just like any witness on the stand has a right to be refreshed at any stage by looking at anything. We'd ask that the prospective juror remain in the courtroom. Second, we've done it historically as a matter of practice. Further, we have the white noise sound system that precludes any invasion or any fear that the prospective juror is going to be somehow tainted by us discussing matters at the bench. So I don't think there's any danger in it. But I think it's a necessity in a trial of this fashion and the size of the jury.
No, I did not ask to leave this at the discretion of the court. I specifically stated that the state requests that you deny their request. Mr. Wiggs definitely seems to have a habit of citing case law that does not actually have anything to do with the issue at hand. For this matter, he has cited cases dealing with refreshing the recollection of a witness, which has nothing to do with jury selection. He has also cited case law about that deals with 3850 claims dealing with whether or not an attorney should have stricken a juror who had, through his statements, shown bias. He does not cite anything that has to do with the issue that he wants the court to do, which would be the rule of criminal procedure, which states that these strikes should be done outside of the presence of the jury. The issues that...
Outside the hearing or outside the presence?
Outside the hearing. I apologize.
Right.
However, I think it's important to remember that our job here is to maintain the best record possible so that if this is ever transcribed, that the court reporters can go ahead and actually hear what is happening. I pulled the jury selection from the case where this court actually allowed the procedure as outlined by Mr. Wiggs. And I have the recording of that if the court would like to hear it for itself. I would say that it is much more difficult to hear the bench conference when people are whispering and trying to maintain the spirit of this rule while we are up there doing strikes and having the white noise sound played, as opposed to if we were sitting out here in front of microphones and actually establishing what our reasoning for challenges might be and any sort of legal argument that we may have. Any sort of due process claim fails because it is exactly the same for both sides, whichever route we go. But I believe that it is much more important to make sure we have a record of what the legal arguments as to any sort of juror strike should be than anything that Mr. Wiggs has outlined in his motion.
May it please the court. Yes, Judge, I don't know if Mr. Camuccio just doesn't understand the concept I'm arguing, but to say that the person can be refreshed, yes, that's a statement that I made in the motion by analogy. No, there's no clear case law on this. There's not. It's a discretionary matter with the court. I didn't see any case law or any argument by the state. Otherwise, the legislature has approved this white noise system. If we go by what Mr. Camuccio is saying, we'll just eliminate it, Judge. We'll never have use of it again in a courtroom. But I don't think that's the concept or the principle that the court wants to follow. But I stated in my motion that any witness, by comparison, any witness on the stand, if they're not refreshed at any stage, they have a right to look at anything to refresh themselves. So I said, comparatively, by analogy or argument, why is a defendant, why would you take all the jurors out of the room and have a mass of jurors sitting outside when you're doing back strikes and you've got multiple strikes in total and leave the defendant confused? I've sat there and people are asking me sometimes when they are removed from the courtroom, well, what's that person? Who was that person? Was that the teacher? Was that the this, that? And you spend more time trying to keep track of where people are seated, which can raise a 3850. Okay, and I said that in my motion. You got to only greaten the odds that you may have a problem down the line on an appeal because you just didn't impose a safeguard and leave them in the courtroom. So I don't know what policy the state thinks they're advancing here to object to this, but I see that there's a warranted and a healthy process in leaving the jury in here instead of returning and seeing it up on an appeal and having to readdress the issue again.
All right. I'll grant the defense's motion. I'll allow the Venire members to remain in the courtroom during the entire jury selection process. Okay, we're on to states number 6, which is states.
All right, we're going to continue listening to that hearing, but we're going to pause it for a second, give us an opportunity to bring in our guest for this hour, Los Angeles defense attorney Matthew Barhoma. Matthew, thank you so much for joining us this hour as we're listening to this hearing take place in Florida. Of course, these are pre-trial hearings. This trial is expected to start in a few weeks here, I believe September 9th. And what a crazy case this is. So we know Michael is dead, and either the daughter did it, which she has admitted to or confessed to, or the wife did it and she's saying she did not do it, but her daughter did do it. What are your takeaways as we start to, prep for this case?
There's a lot going on in a case like this, okay? There's motive, there is faulty confessions to some extent, maybe. There is a prime suspect, maybe someone who has carried out conduct even after the fact that everyone around them is testifying to, or is at least alluding to, being unusual, right? So there's a lot of takeaway here in that what's to come on this is going to be maybe a pretty big evidentiary portion of this. There's going to be a lot of evidence that I think is going to come out in this that's really going to maybe sway this jury.
Some of that evidence could be these Facebook messages that they're talking about in the hearing, and saying that one of his friends, Michael's friends, had said that Michael was missing. He thought, this doesn't sound right, these messages on Facebook. It doesn't sound like the tone of Michael. He eventually then reported him missing, and the state wants to bring in all of these Facebook messages that it appears that the defendant ended up writing, impersonating her husband, who was now deceased.
Yeah, that's exactly it. I mean, everyone around is attesting that this is unusual conduct, very unlikely, and I think that that's going to be very prevalent evidence in this case. I think that that's going to really, I mean, it's going to sit in the room, right? And I think both sides are going to have to grapple with how they present it to the jury.
Exactly. And, you know, somebody could make the argument that, okay, yeah, mom was pretending to be him because the daughter did actually pull the trigger and kill dad, and she just was continuing to cover it up to save her daughter. So who knows how this is all going to play out in court? We'll have to wait and see as we continue to watch those hearings. Matthew, thank you so much for your insight. We're going to get in a quick break, but don't go anywhere. We're coming right back. You're watching Court TV, your front row seat to justice.
Friday nights, the WNBA is on ION. Tonight, the Indiana Fever head to Chicago to take on the Sky, followed by a showdown in Seattle, where the Storm face the New York Liberty. Coverage starts tonight at 7. Check local listings for games in your area. ION, it's on.
Tonight on Closing Arguments, did this mother-in-law orchestrate a murder? Breaking down today's big hearing in the case against Donna Adelson.
Closing Arguments tonight at 8/7 Central, only on Court TV.
Back now to Florida, where we are watching a motions hearing for defendant Laurie Shaver. She is charged with second-degree homicide and accessory after the fact in connection to the 2015 fatal shooting of her husband, Michael, who worked at Disney World. But Shaver claims that her daughter, who was 7 years old at the time, later admitted to being the one who killed Michael. Let's get you back into court now, where the attorneys are about to argue a motion relating to witness testimony about the Shavers' marriage.
Yes, Your Honor. Rich Buxton, thank you.
Yes, sir.
The state's motion really focuses on two different things. The state opposed the defense-listed Mr. Narvaez as a witness. The state opposed him. I attached a copy of the deposition to the motion for the court's benefit. The state's focuses on two separate sets of statements made to Mr. Narvaez. The first set of statements are made to him by the defendant, Laurie Shaver. Mr. Narvaez indicated that Ms. Shaver, the defendant, told him that she and the victim had a rocky relationship and that there had been a history of abuse. Those statements the state is seeking to exclude because they're clear self-serving hearsay. As we all know in this room, the statements or admissions against a party opponent are admissible, which is why the state is able to introduce the defendant's statement against her. These are self-serving statements. They are inadmissible and can't be presented through the defense by asking the witness, did the defendant tell you X, Y, and Z, or asking the witness, what did the defendant tell you? I've cited the three cases of many that apply to self-serving hearsay in my motion. This concept would also apply to any witness that the defendant made similar statements to, not just Mr. Narvaez, but because my motion is focused on Mr. Narvaez, I'll limit my discussion to just that. The second portion of the state's motion focuses on statements made by the defendant's daughter, Isabel Shaver, to Mr. Narvaez. As we know, the defense is going to potentially be that Ms. Shaver, Isabel Shaver, was the one that actually shot the victim. Ms. Shaver made statements to Mr. Narvaez years later indicating such. Those are clear out-of-court statements made by a witness, Ms. Isabel Shaver, to Mr. Narvaez, used to prove the truth of the matter asserted, so they are clearly hearsay. By no means by the state's motion are we trying to prevent Ms. Isabel Shaver from testifying. That's not the focus of the motion. The focus of the motion is to prevent witnesses from being questioned about hearsay statements made by Ms. Isabel Shaver. So, because statements made by Isabel Shaver to Mr. Narvaez are clear hearsay, the question is there a hearsay exception to those statements? And the only exception potentially that could be raised is that it's a statement made by the declarant against the declarant's penal interest, pursuant to 90.804(2)(c). In order for that hearsay exception to be established, the defense, because they're the proponent of the evidence, would have to prove three things. Number one, the declarant, Isabel Shaver, is unavailable. Well, we know that's not the case because Isabel Shaver has given a deposition, and by everything I know, she is ready, able, willing, and is going to testify in this case. So that prong cannot be met. Therefore, the exception for a statement against penal interest cannot be established. You don't have to get to the second and third prongs because, again, Ms. Shaver is available. If you do want to go into further analysis, and which you don't need to, but if you did, the statements are also unreliable. Again, I don't think you need to get this far in the analysis, but they are unreliable considering that Ms. Shaver was questioned on several occasions and never indicated this before. There's some scientific evidence refuting her statements, as well as the testimony of Jeremy Townsend. But again, I'm not going to go into that really in detail because, again, the state's position is Isabel Shaver is available, therefore prong one of this cannot be met, therefore the exception doesn't apply and the statements are hearsay. Pursuant to my ethical obligation, there is a line of cases which I included in the motion, which talks about constitutional due process, and that is the Chambers versus Mississippi case. And I included that because I felt the court needed to be aware of it and needed to at least know about it, so I wanted to make sure the court was aware, and if the defense wants to argue this. But it's important to note the Chambers versus Mississippi case cites 401 U.S. 284, 1973 case. That case addressed a Mississippi case in which a third party confessed to a murder to several people, but then recanted the confession. The state obviously did not call this witness for clear reasons. The defense then tried to call that witness and impeach the witness on the statements he made confessing to the murder to other people. Mississippi had a rule which prevented the defense from impeaching their own witness. Florida doesn't have that rule. So the defense could not get the information that this third party confessed to a murder out by calling the witness and impeaching the witness. So then the defense in Chambers versus Mississippi said, okay, we're going to call those three people that the witness confessed that he committed murder to. So they called those witnesses, and the problem with that was it was hearsay, and Mississippi did not have an evidentiary provision allowing, like Florida does, allowing for a declaration against penal interest. So the defense wasn't able to present that information through those witnesses. So because of those voids in Mississippi's evidence code, the U.S. Supreme Court said that the defendant had a constitutional due process right to get the information to the jury, and the evidence code that was in place in Mississippi did not allow that to happen. So what Chambers in Mississippi versus Mississippi basically did was say, on a constitutional due process ground, they allowed those statements, even though they were hearsay, to be admitted to the jury because the defense had no other way of getting that information before the jury, and the U.S. Supreme Court said that's not fair from a constitutional due process. Florida has these provisions, unlike Mississippi. So Florida's evidence code distinguishes Chambers versus Mississippi in that line of cases from the case we have here, this instant case. Chambers pointed out that its holding was not establishing new standards of constitutional law and was not dismissing the authority of the states over their own trial rules. So Chambers didn't find that the evidence code is meaningless and we're going to throw it out and let everything in. Jones v. State, in Florida case, 709 Southern 2nd 512, it's a Florida 1998 case. The court cited Gudinas, which was 453 Southern 2nd 17, Florida Supreme Court 1984, which said Chambers was, quote, limited to its facts due to the peculiarities of the Mississippi evidence law, which did not recognize a hearsay exception for declaration against penal interest. So our Florida Supreme Court basically determined that Chambers wasn't applicable because Chambers was meant to fill that void in Mississippi law that Florida did not have. In this case, the defense has every ability whatsoever to present this evidence to the jury, which Chambers couldn't do, but the defendant does because they can call Isabel Shaver and talk about whatever Ms. Shaver wants to say. So that evidence can be presented to the jury by simple traditional methods of calling a witness. The state's focus is again, not to prevent Isabel Shaver from testifying or limiting her testimony like in that fashion. The state's focus is to prevent the defense from questioning witnesses about the hearsay statements made by Isabel Shaver to Adam Narvaez. Thank you, Your Honor.
Thank you. Mr. Weeks?
Yes, ma'am. Please support.
Yes, sir.
Judge, we're not offering testimony of Mr. Narvaez to speak about the truth of the statements of Isabel Shaver, but the circumstances under which Isabel Shaver has come forward. There's inferences and allegations that, so to speak, she was called late in this game. The record shows she was not, that Kelly Johnson was appointed as a consequence of her moving forward. Mr. Narvaez, his involvement was he spoke to Isabel and then had a talk to Laurie Shaver, and thus there was a consensus at a certain stage to allow Isabel to move forward with their testimony. Thus, that's how Kelly Johnson got appointed as.
Before we head to break, we do have some breaking news to tell you about. This is out of New Jersey, where NHL player Johnny Gaudreau and his brother were fatally struck while biking by a car driven by a man who was possibly under the influence. The driver, 43-year-old Sean Higgins, has been arrested and charged with 2 counts of vehicular homicide. He's being held without bail. We will continue to bring you updates on this story throughout the day. We'll be right back. Back to Court TV Live. I'm Kelly Craft. We continue now with the pre-trial motions hearing for Laurie Shaver that's taking place in Florida. Now, she is accused of murdering her husband and hiding his body for more than a year. But Shaver is claiming that her 7-year-old daughter, at the time, confessed to the killing. Let's take you back into the courtroom now, right where we left off.
The steps that she did. It's just to show a sequence of steps, as opposed to putting a witness on the stand as if we've just pulled her out of off the street. It just shows a sequence of events with the timing. It's not to prove the truth of the statements of Adam Narvaez, but to show the timeline and why the minor child stepped forward. That's why. And that's a non-hearsay purpose. You know, it's not to just show that she told me this, okay? It's, you know, what happened beyond that point. So that's the reason it would be offered.
Yes, sir.
Which is non-hearsay.
State's response.
It's being used. If they're eliciting statements made by Isabel Shaver out of court that I shot my father, that is being used to prove the truth of the matter asserted. That's the whole point of it. To explain the circumstances surrounding it is not a valid purpose. That's like me asking a detective to talk about hearsay because it establishes, you know, that's like me asking a detective, who did you talk to and what did they say, just to establish the context of the investigation. That's clearly hearsay, and this is no different.
The testimony has not been proffered. Now, the state is saying this is what the child's going to say, and this is how she's going to say it. Judge, I think the state is getting ahead of themselves, assuming everything is hearsay that child could say. The context in which the child makes those representations defines whether it falls outside of the hearsay rules. But the state's saying that child told Mr. Narvaez, I did X, Y, and Z, and then, you know, she's offered as a witness. Okay? No, that's not the context in which those statements will come forward. She confided in Mr. Narvaez about certain facts and events. She confided in Mr. Narvaez about her desire to testify and come forward because of her emotional feelings in this case. That's not hearsay. It explains a timeline and why this child is going to be here testifying. That she's not being thrown under the bus, as the state may suggest, but that there's a rational basis and a timeline why she stepped forward.
All right, is there anything further?
No, sir.
All right, right, I'll grant the state's motion. The court finds that the testimony regarding a timeline is hearsay, and the court will make the appropriate hearsay rulings at trial.
Yes, thank you.
I believe that leaves us with Mr. Wiggs' motion, which is a motion to request judicial notice of contents of the clerk's file.
Yeah, Judge, that file just is a standard motion asking permissive judicial notice. I don't know exactly what's going to be presented by the state. You'd ask the state to try to work with me and tell me what exhibits they want to use at trial. Today, I confided with the state whether they would do that. Mr. Camuccio says he hasn't figured that out, so I presume that's a no. Okay, so at this stage, I don't know what the state may show, but it may open the door to the introduction of other evidence. So I'd ask the court to leave that door open for permissive judicial notice at trial.
All right, state's response?
Your Honor, we obviously don't have any issue with the fact that the documents within the court file themselves are authentic for purposes of request for judicial notice, but that is not an avenue for admissibility. Just because it's in the court file doesn't mean you can just say, this is from the court file, so jury, here you go. As I said previously, Mr. Wiggs does appear to have a habit of, in front of the jury, referencing and marking pieces of evidence that clearly are inadmissible as far as reports and depositions, and then requiring the state in front of the jury to object to things that are just clearly inadmissible. If he wants any of these items marked, or if he thinks any of these things have been opened up the door to admissibility, I would just ask that outside the presence of the jury, that be proffered as to what the document is and the reason for how it is now admissible, simply because it is in a court file or in this court file does not make it evidence in this case. And all I'm asking is outside the presence of the jury that be proffered.
If Mr. Camuccio read the motion, he'd see it's a request for permissive judicial notice. Not mandatory judicial notice. I'm not going to be throwing things at a jury judge here. I did ask the court to take mandatory judicial notice of the child's birth certificate, which the child did, which the court did. Okay? This is a request for permissive judicial notice in the event that the door opens. I'm not going to be throwing things at a jury. I would ask the court, Judge, can we introduce this at this stage if the state has opened the door on this issue? So, no, it's characterized right in the plain language of the motion itself for permissive notice, and that would be done with the court and with the state.
Oh, to that extent, the request is granted.
Yes. Thank you, Judge.
Is there anything further?
As far as my request that these items be proffered outside the presence of the jury before they're just referenced and marked in their presence, is the court agreeable to that?
Do you have any objection to that, Mr. Wiggs?
No, Judge, and I assumed we would do that. You know, I'm not just pulling things out and throwing at a jury. We would discuss it at the bench.
All right, without objection, the state's request is granted.
Thank you.
Thank you.
I believe that addresses all the matters before the court today. Is there anything further before the court?
The judge, yesterday I had referenced the preliminary jury instructions as far as the two alternate portions from the standard that talk about devices, and I just wasn't sure if you had made a decision on which one of those two alternates that you wanted me to put in the instructions to present to you for the preliminary.
Yes, sir, and I believe it would be best to exclude any devices from the courtroom.
All right, so that would be option B, I believe.
Option B, yes, sir.
Yes, sir. I'll make that change, email it to everyone. I've received Mr. Wiggs' proposed jury instructions, and there are some special instructions in there that we'll have to address at some point whenever the court feels it's appropriate.
Right.
All right, we can address that
Just
during trial or during trial.
Right. Just going back, just to clarify the record too, with regards to my motion in opposition to the state's request for a jury summary, in that I had cited Smith versus Carlisle. I had given the state that, and the decision is 378 Southern 3rd at 1213. The state had complained they didn't have a copy of any authority on that. They have it right in the documents that I've handed out as well.
All right, is there anything further?
Yes, sir. Nothing further, Judge.
All right, thank you all for attending. We are adjourned.
Okay, and that concludes the motions hearing there in Florida. Still with us, Los Angeles defense attorney Matthew Barhoma. Matthew, what is your take on the hearing? Obviously very important, because now at the conclusion, defense counsel as well as the prosecutor can go back and start formulating their theories for the case as to what decisions the judge made here. What can we bring in? What can't we bring into this trial?
You know, this is where real lawyering really takes place, right? It's actually a lot of these pretrial conferences where major arguments, major decisions are made. And, you know, I think that this was well argued. There was many arguments across the bench on both sides on what would be allowed to come in. And it seems like there's some big decisions. I mean, the hearsay decisions, I think, were pretty broad. And, you know, they're maybe even preemptive. And some of these decisions, I think, may be changed in the future, depending on how testimony comes about. So depending on how each witness comes about and testifies and how each side lays foundation, I think that there could be grounds to change some of these rulings to maybe allow various things. And the defense alluded to it. They said that, hey, the prosecution may open the door.
Yeah, and that's an important point, because if the judge denies a motion, then at trial, if that door is open, then that's another way that an attorney can use to get in evidence. And so that's what defense counsel was saying here. You know, just fast forwarding to when this trial ends up taking place, if you want to go with the mom's theory that the daughter did it, the mom, there's going to have to be some sort of explanation as to, well, the husband was found buried in your backyard underneath a fire pit 3 feet down. Authorities had come to her house to ask to kind of search, and at first she was cooperative, but not so much when they said they wanted to look in her backyard. I mean, there's going to have to have some explanation as to how he ended up there. She had some role. She had some role in it.
Certainly, maybe even an accessory after the fact. But, you know, I agree with you. Mom has a lot of ground to cover here. The reason is you got to get the jury to take this leap and say, okay, maybe the daughter did it. And not only that, she's already put out, you know, a whole, you know, essentially like an interview on YouTube alluding to the fact that, you know, I love my kids. My kids are my number one. And how is that going to come across to the jury, right? When you're blaming your daughter, you know, if your kids are number one, maybe you fight this case for what it is, and you fight the evidence for what it is without putting your daughter forthfront. So I think mom has a lot of ground to cover for this jury, and she's going to be asking this jury to make a lot of leaps.
Absolutely. Matthew, thank you so much for your insight today.